The spirit of the common law. 3. The courts and the crown. On a memorable Sunday morning, the wrath of November, 1612, the judges of England were summoned before King James I upon complaint of the Archbishop of Canterbury. It appeared that the High Commission, an administrative tribunal established for the regulation of the Church, had begun to take cognizance of temporal matters and to deal with lay offenders. Not only was this tribunal wholly unknown to the common law, but it decided according to no fixed rules and subject to no appeal. When, accordingly, it sought to send its pursuivant to the house of this or that lay subject and arrest him upon a complaint of a wholly temporal nature, the Court of Common Pleas stopped the proceeding with a writ of prohibition. To meet this judicial insistence upon the supremacy of law, it was suggested that the king might take away from the judges any cause he pleased and decided himself, and the immediate business of the Sunday morning conference with the judges was to explain this proposition and hear what they could say to it. The Archbishop proceeded to expound the alleged royal prerogative, saying that the judges were but the delegates of the king, wherefore the king might do himself, when it seemed best to him, what he left usually to these delegates. Headed that this was clear, if not in law yet beyond question in divinity, for it could be shown from the word of God in the Scripture. To this Coke answered on behalf of the judges, that by the law of England the king in person could not adjudge any cause. All cases, civil and criminal, were to be determined in some court of justice according to the law and custom of the realm. But, said the king, I thought law was founded upon reason, and I and others have reason as well as the judges. True it was, Coke responded, that God had endowed his majesty with excellent science and great endowments of nature. But his majesty was not learned in the laws of his realm of England, and causes which concern the life or inheritance or goods or fortunes of his subjects are not to be decided by natural reason, but by the artificial reason and judgment of the law, which law is an art which requires long study and experience before that a man can attain to the cognizance of it. At this the king was much offended, saying that in such case he should be under the law, which it was treason to affirm. Coke answered in the words attributed to Bracton, that the king ought not to be under any man but under God and the law. But this was not the last of such conferences, and in the end Coke, who would give no pledge to do otherwise than administer the law as a judge should, was removed. In 1787 the legislature of Rhode Island, having put forth paper money of the nominal value of £100, made it penal to refuse to accept the bills in payment of articles offered for sale or to make any distinction between them and gold or silver coin, and provided further that if anyone were accused of that heinous offence, he should be tried forthwith in an inferior court by judges without a jury, on a summary complaint, without any continuance and with no appeal. One Whedon, being charged with violating the statute, objected that trial before such a special court uncontrolled by the supreme judiciary and without a jury was repugnant to the charter which stood as the constitution of the state, and hence that the statute was void. The judges sustained this objection. Thereupon, on the last Monday of September, 1787, the judges were summoned to appear before the legislature much as Coke and his colleagues had appeared before James I. The judges appeared, and two of them made learned and convincing arguments that they could not be compelled by statute to send a citizen to jail without trial by jury when trial by jury was guaranteed by the Constitution, the supreme law of the state, under which the legislature itself was constituted. The legislature, however, voted that it was not satisfied with the reasons of the judges, and a motion to dismiss the judges from their offices followed and would doubtless have prevailed had it not appeared that the Constitution unhappily required the deliberate process of impeachment. Like cases occurred at the time in many states. Again in the 20th century, in the movement for recall, judges were to be sent for to explain themselves to the sovereign. Bills of Rights in our constitutions, state and federal, had been administered by courts as the supreme law which they purport to be. Thereupon the people were urged to send for the judges, to determine that their reasons were unsatisfactory and to dismiss them. The alternative proposition was that the people proceed to decide the case directly, as James I sought to do. There is a close parallel here in more senses than one. In the 17th century, it was progressive to insist upon the royal prerogative. Those who thought of the king as the guardian of social interests and wished to give him arbitrary power, that he might use it benevolently in the general interest, were enraged to see the sovereign tied down by antiquated legal bonds discovered by lawyers in such musty and dusty parchments as Magna Carta. To them, the will of the king was the criterion of law, and it was the duty of the courts, whenever the royal will for the time being and for the cause in hand was ascertained, to be governed accordingly, since the judges were but the king's delegates to administer justice. In the 18th century, the center of political gravity had shifted to the legislature. That body now thought of itself as sovereign and conceived that, no matter what the terms of the fundamental law under which it sat, the courts had but to ascertain and give effect to its will. At the end of the 19th century, the center of political gravity had shifted to the majority, or more often the plurality of the electorate, voting at a given election, and those who thought of pluralities and militant minorities as the guardians of social interests and would give them arbitrary powers, that they might use them benevolently in the general interest, were enraged to see the sovereign tied down by what seemed to them dead precedents and antiquated legal bonds discovered by lawyers in 18th century bills of rights. The judges were but delegates of the people to do justice. Therefore, it was conceived, they were delegates of the majority or plurality that stood for the whole in wielding general governmental powers. Once more it was insisted that their will of the ruling organ of the state, even for the time being and the cause in hand, must be both the ultimate guide and the immediate source to which judges should refer. Toward king, legislature and plurality of the electorate, the common law has taken the same attitude. Within the limits in which the law recognizes them as supreme, it is but to obey them. But it reminds them that they rule under God and the law. And when the fundamental law sets limits to their authority or bids them proceed in a defined path, the common law courts have consistently refused to give effect to their acts beyond those limits. Juristically, this attitude of the common law courts, which we call the doctrine of the supremacy of law, has its basis in the feudal idea of the relation of king and subject and the reciprocal rights and duties involved therein. Historically, it goes back to a fundamental notion of Germanic law. Philosophically, it is a doctrine that the sovereign and all the agencies thereof are bound to act upon principles, not according to arbitrary will, are obliged to conform to reason, instead of being free to follow caprice. Along with the doctrine of judicial precedent and trial by jury, this doctrine of the supremacy of law is one of the three distinctively characteristic institutions of the Anglo-American legal system. It became definitely established therein as a result of the contests between the courts and the crown in the 16th and 17th centuries. Hence we may inquire, 1. What led up to these contests? 2. What effect did they have on the common law tradition? And, in particular, how did they contribute to the exaggerated individualism of that tradition in the 19th century? And, 3. What is the significance of the resulting doctrine of the supremacy of law for the law of the future? Throughout the Germanic law books of the Middle Ages, says Husserl, runs the idea that law is a quest of the creature for the justice and truth of his creator. All notion of arbitrary will was foreign to it. The conception that the will of the sovereign had the force of law came from Rome, if not, indeed, from Byzantium. The Germanic conception was instead that expressed in the phrase attributed to Brachton, that the king was under God and the law. The Germanic polity always postulated a fundamental law above and beyond mere will. Moreover, it conceived that those who wielded authority should be held to account for the conformity of their acts to that law. Perhaps the extreme instance is to be found in the Salic law, which prescribes that where a creditor has duly appealed to the count for justice and the count does not act with no sufficient reason, he shall answer with his life or redeem himself with his wergeld. But when he does act pursuant to such an appeal, if he goes beyond enforcement of what was due, he is likewise to answer with his life or redeem himself with his wergeld. But the conception developed as the basis of public law only in England. There the establishment of strong central courts, purporting to administer the common custom of the whole realm, the strong central administrative power of the king, and the early formulations of the feudal duties of the king toward his tenants-in-chief afforded a unique opportunity for the evolution of a legal doctrine of the legal duties and responsibilities of those who wield governmental powers. Two cases of the reign of Edward III show the first phase of the doctrine. In 1338, in an action of Riplevin for cattle distrained by a collector of the king's taxes, it appeared that the collector had no warrant under seal. The plaintiff demurred to his avowry, that is to his plea that he took as collector of taxes, and the court rendered judgment for the plaintiff. Men could not go about the realm distraining the property of the subject or purporting to collect the king's taxes without a special warrant. The next year, the Court of King's Bench, having convicted Reginald de Nerford and others of a forcible disseisin, issued a writ of exegie faces, outlawry, against them. This writ was returned by the sheriff, who reported that he had received a letter from the king under his private seal to the effect that he had pardoned the defendants and commanding that they should not be put to damage, wherefore he had not executed the writ. The court would not listen to this. It told the sheriff he could not justify a refusal to execute a writ of the king's court by showing a mere private letter from the king, and after imposing a fine upon the sheriff, it issued a new writ to outlaw the defendants. In other words, Edward III, King of England, might pardon offenders, but he might not instruct a sheriff to disobey the precepts of the law. If he did, the sheriff could not justify his disobedience thereby. When he acted as king, his acts were those of the law. When he acted by private letter as Edward Plantagenet, he could not interfere with the due course of the law which bound the whole realm. It will be noted that in each of these cases the point was largely one of form. If the tax collector had held a warrant in due form, if the king had pardoned Reginald de Nerford and his companions in the mode which the law recognized, there would have been no question. Yet there was more here than form. Requiring the king and his agents to act in due form, if their acts were to have legal validity, was, in an age of formal law, the first step toward requiring him and them to act within the legally appointed limits of their authority. When Fortescue wrote in praise of the laws of England a century later, he could lay down dogmatically that the power of the English king was not regal, in the sense that he could make what innovations and alterations in the laws he pleased and impose on his subjects what burdens he chose, but was instead political. It was not the personal government of Edward or Henry, it was the political government of the King of England, exercised within the bounds which the law and customs of the realm had established. In this wider form, the doctrine soon required the courts to pass on the validity of royal acts of a very different character. At common law the king is parens patriae, father of his country, which is but the medieval mode of putting what we mean today when we say that the state is the guardian of social interests. In the feudal way of looking at it, the relation of king and subject involved duties of protection as well as rights to allegiance. The king, then, was charged with the duty of protecting public and social interests, and he wielded something very like our modern police power. But this power was limited on every side by the maxims of the common law and the bounds set by the law of the land. It was a maxim that the law had so admeasured the prerogatives of the king that they should neither take away nor prejudice the inheritance of anyone. Naturally the royal power of protecting social interests soon came in conflict with such a maxim. A few examples are worth recalling. Henry IV granted the measuring of wool on cloth or canvas that should be brought to London by any stranger or denizen, taking a penny of the buyer and another of the seller for each piece measured. The judges held that this was not a grant in the public interest, that it tended to the burdening, oppressing and impoverishing of the king's subjects and not to their advantage, and therefore the said letters patent were void. Again, King Henry VI granted to the Company of Dyers in London the power to search for cloth dyed with poisonous dyes and to seize and confiscate it, if found. The judges held this also against the law of the land on the ground that no one's property could be forfeited by virtue of letters patent without adjudication and an opportunity to be heard. There is a long succession of these cases between the reigns of Henry IV and Elizabeth in which the Crown is manifestly endeavouring to make the royal power to protect social interests a source of revenue or a means of enriching favourites, while the courts insist it shall be exercised according to settled principles of reason and within limits defined by the law. To this extent the common law was struggling with the prerogatives of the Crown precisely as today it struggles with the prerogatives of majorities and pluralities. There is, however, a significant difference. In these contests between courts and crown prior to the Stuarts, the courts had been guarding social interests by preventing perversion to quite different uses of powers which could be used rightfully only to further public or social interests. In the 19th century we find common law courts going much beyond this and thinking themselves bound to put limits in the interest of the individual to social control for the social interest. This change in the spirit of the common law resulted from the political phase of the contests between courts and crown under the Tudors and Stuarts and from the political and juristic theories of the 18th century. It is probable that the further extension of the legal doctrine of supremacy of law has its juristic origin in the medieval conception of the distinction between temporal and spiritual jurisdiction and the entire incompetency of temporal power in the domain of the spiritual. This proposition was so fundamental that medieval judges no doubt thought of temporal administrative or legislative acts which sought to invade the field set apart for the Church much as judges of today might regard the statute sarcastically proposed by an English conveyancer be it enacted that during the month of April of each year the King's loyal subjects shall be at liberty to and are hereby enabled to go forth without umbrellas upon any and all public streets, roads and highways without getting wet. Accordingly in the reign of Henry VII a majority of the Court of Common Pleas laid down unhesitatingly that an Act of Parliament for seizing the lands of alien monasteries into the King's hands could not make the King a parson. No temporal act, they said, can make the king parson without the assent of the head of the church. In other words, there was a fundamental law, dividing temporal power from spiritual power, which ran back of all states and of all human authority, and even acts of parliament, if they ran counter to this fundamental law, must be disregarded. When at the Reformation the temporal power became supreme, decisions of this sort seemed to sanction a doctrine that the sovereign, whether king or parliament or people, was bound to act within certain limits imposed upon all government by fundamental principles of right and reason which it was beyond the power of lawmakers to change. Such was the legal situation when a new movement in English polity required the common law to fight for its life and gave a political significance to its power of judging of the validity of royal acts and determining whether they were in truth acts of the sovereign. In the middle of the 16th century the common law courts, struggling to meet the wants of England of the Reformation by a feudal property law and a criminal law devised primarily as a substitute for the rough and ready justice of an outraged neighborhood in the days when self-help was the staple remedy, found themselves in a position very like that of American courts, developed in and for the pioneer or agricultural societies of the first half of the 19th century which are struggling to meet the wants of today with the rules and the machinery devised for such communities. Moreover, an era of liberalization was at hand. The preceding period, a period of strict law, had regarded only conformity to the letter of the law and compliance with prescribed form. The stage of equity and natural law was at hand, a stage which involved an infusion of morality, an infusion of purely moral ideas developed outside of the legal system. Such periods of liberalization, in which the law is made over by reception of ideas from without, have always involved for a time a movement away from law, a temporary reversion to justice without law. In such periods at first the chief reliance for obtaining justice seems to be the power of the magistrate, and arbitrary power is looked upon complacently since it is taken to be the sole means of escape from the bonds imposed by the strict law. Thus in the United States today, in a period of legal development which has much in common with the one we are considering, a movement for liberalization, an infusion into the law of ideas developed in the social sciences, has led to a tendency away from courts and law and a reversion to justice without law in the form of revival of executive and even of legislative justice and reliance upon arbitrary governmental power. Accordingly, in the middle of the 16th century lawyers began to complain that the common law was being set aside. Very little business of importance came longer to the king's courts of law. The courts, which for 300 years had been shaping the law and holding even the king to the limits prescribed thereby, seemed to be losing their hold. The law seemed to be fashioning in quite another type of tribunal and by other hands than those of common law lawyers. In criminal causes that were of any political importance, Maitland tells us, an examination by 2 or 3 doctors of the civil law threatened to become a normal part of our procedure. The living law seemed to be making and applying in the King's Council, in the Star Chamber, in the Court of Requests and in the Court of Chancery, all of them courts of a Roman, and, what was more important, a summary procedure. It seemed that judicial justice, administered in courts, was to be superseded by executive justice administered in administrative tribunals or by administrative officers. In other words, there was a reaction from justice according to law to justice without law, in this respect entirely parallel to the present movement away from the common law courts in the United States. In place of the magistrate limited by law and held to walk strictly in the paths fixed by the custom of the realm, men sought to set up a benevolent guardian of social interests who should have power to do freely whatever in his judgment protection of those interests might involve. In place of deliberate judicial tribunals, restrained by formal procedure and deciding according to fixed principles, they turned to off-hand administrative tribunals in which the relations of individuals with each other and with the state were adjusted summarily according to the notions for the time being of an administrative officer as to what the general interest or good conscience demanded, unencumbered by many rules. A valiant fight against this movement for administrative absolutism was waged by the common law courts, and in the end the older law prevailed. The Court of Chancery was the only one of the Romanized courts of the Tudors and Stuarts which survived, and that tribunal little by little was made over along common law lines till it became an ordinary English court. Moreover, the doctrines which were evolved in the course of judicial administration by these tribunals were made into law and received into the common law system. The law was liberalized, but it was still the common law. The chief weapon which the common law employed in this contest, and the one about which the contest raged, was the doctrine of the supremacy of law. That doctrine, therefore, became established among the fundamenta of our legal tradition as a result of the victory. But the victory gave it a new scope and a new spirit. Its scope for a time broadened, so as to make of it a doctrine of limitations upon all sovereign power, independent of positive law and at most simply declared thereby. Its spirit became individualist. It became a doctrine that it was the function of the common law and of common law courts to stand between the individual and oppressive action by the state, that the courts were set up and the law existed to guard individual interests against the encroachments of state and of society. Thus the Sunday morning conference between King James and the judges, which is the glory of our legal history, led in the 19th century to constitutional doctrines that for a time enabled a fortified monopoly to shake its fist in the face of a people and defy investigation or regulation. Too often it led the law in the last century to stand full-armored before individuals, natural and artificial, that needed no defense, but sallied from beneath its aegis to injure society. Both the broadening of scope and the change of spirit demand notice. It has been noted already that in the reign of Henry VII the courts had enforced against an Act of Parliament the medieval dogma of the distinction between temporal and spiritual jurisdiction. To Coke, the champion of the common law in the contest with the Stuarts, such decisions established a general doctrine of the competence of the courts, since they administered the law and law was reason, to compel not merely all private individuals, and all agents of government, but the very sovereign itself, to keep within the bounds of reason, by refusing to recognize or give legal effect to acts or ordinances of the sovereign which went beyond such bounds. When an act of Parliament, he said boldly, is against common right and reason, the common law will control it and adjudge such act to be void. The events of 1688 in England established the supremacy of Parliament, and Coke's proposition failed to maintain itself. But experience of review of colonial legislation with respect to its conformity to charters, applied to written constitutions and bills of rights, led us in the United States to carry the supremacy of law to its logical limits, and indeed to go beyond such limits and practically adopt Coke's conception of a control of legislation upon fundamental principles of right and reason. 18th century ideas of natural law and the assumption that the 17th century legal rights of Englishmen were the same as the natural rights of man, which were the staple of juristic and political thought in the 18th century, combined to give Coke's theory of the supremacy of law much currency. When our courts first came to pass upon constitutional questions, what they read in Koch's Second Institute and in his report of Bonhomet's case appeared but a common law version of what they read in French and Dutch publicists as to an eternal and immutable natural law, by which all human laws must be measured, and of which, in order to have validity, they must be declaratory. Accordingly it became usual to speak of limitations involved in the very idea of free government which go back of and are only declared by constitutions and bills of rights. It became usual to think, not of the text of the bills of rights, but of these supposed fundamental principles of which they were but declaratory. Thus unwittingly at the end of the 19th century courts found themselves too often enforcing not the bills of rights but the individualist doctrines of the historical and philosophical jurisprudence and classical economics of that century. Moreover, for reasons in part growing out of the 17th century contests between courts and crown and in part growing out of 18th century political theory, as has been said, this doctrine of a fundamental law, binding even the sovereign, was taken to be something which existed for individuals to protect them against state and society. Assuming that the abstract individual was the center of all things and that the state existed only to secure his interests, it was thought that courts and law had for their function to prevent use of this machinery, set up to protect the individual and to secure his rights, as a means of oppressing him and depriving him of his rights. To understand this notion, as it developed in the Anglo-American juristic tradition, we must look for a moment at the history of the idea of sovereignty. In the Roman polity the power of making laws was in the populus Romanus. The magistrate had imperium, the power to command the citizens, a name and an idea growing out of the combined civic and military functions of the magistrate in the ancient city-state. To protect society by keeping discipline in time of war and by keeping order in time of peace, the magistrate had a power of command. Later the emperor had delegated to him both of these powers. The people conferred on him their legislative power for life and they made him magistrate for life. Thus arose in the Byzantine period the conception of a sovereign in whom all the law-making and all the coercive powers of organized political society are concentrated, and this conception was handed down to the modern world in the law books of Justinian. Imperium and dominium, the power of the magistrate and the power of the owner, were confused during the Middle Ages. The great landowner was also a territorial ruler. The owner of the manor was also magistrate and judge within its limits. The king was ultimate lord of the soil and also the fountain of justice. Under the reign of the Germanic idea of reciprocal rights and duties involved in such a relation, the royal dominium was more like imperium than the sovereignty of the Byzantine texts. But the breakdown of feudalism, the growth of central national authority in place of the local feudal lordships, and the rise of the nationalist idea at the Reformation, with the accompanying notion of the duty of passive obedience to rulers, gave significance to these texts as a more scientific study of Roman law went forward as a result of the Renaissance and of the humanist movement. In France, where the treatises of widest influence were written, there was coming to be something very like the Byzantine Princeps, and in England if Tudor and Stuart had had their way there would have been a like result. Throughout Western Europe the idea of sovereignty as a control from without, of the sovereign as something external to society and set over it, something with which the several individuals who compose society had made a compact binding them to obedience or to which as of divine right passive obedience was due. Throughout Western Europe this idea superseded the Germanic and feudal conception of a relation of protection and service growing out of tenure of land and involving reciprocal rights and duties. When this idea came to prevail the sovereign was a Byzantine emperor. What it willed had the force of law. Law was not something fundamental and eternal, running back of all states, it was the will of this state or that, the command of this or that sovereign. Whatever the moral duties of sovereigns, they were incapable of legal imitation. They might rule under God, but they certainly did not and could not rule under the law, for they made the law. This conception of law as will has been struggling with the idea of law as reason ever since. When the common law, with its feudal theory of the relation of king and subject and its Germanic theory of the supremacy of law came in conflict with the new conception of sovereignty developed in France on Byzantine lines, it was forced to a position which seemed in practice to assert that the sovereign had legal duties to the subjects, that there was law above and behind all sovereigns which they could not alter and by which their actions might be judged, and that the law stood between the individual subject or citizen and this Leviathan and compelled it to recognize the natural rights of the individual, given him by this eternal and immutable law, or to recognize the terms of the social compact whereby the individual had conferred upon Leviathan his very sovereignty and the latter in return had undertaken to secure those natural rights. At the Revolution, the peoples of the several states succeeded to the sovereignty of Parliament. They thought of this not as feudal but as Byzantine sovereignty, and yet they were afraid, and justly afraid, of these emperors they were setting over themselves, even though the princeps was a fluctuating body made up of a majority or plurality of themselves. Hence by bills of rights they sought to impose legal limits upon the action of those who wielded the powers of sovereignty, while adhering to a political theory of illimitable and uncontrollable power in the sovereign itself. It was inevitable that this compromise between inconsistent theories should sooner or later produce a conflict between courts and people. In that conflict, which became acute in the first decade of the present century, each was in a measure right and each was in a measure wrong. Talk of stubborn facts, says Dr. Crothers, they are but babes beside a stubborn theory. The conflict between courts and people was not a contest of theory with fact. It was a conflict of two stubborn theories. It was a conflict of juristic theory with political theory as to what law is, whence it comes and whence it derives its force. Each theory was the outgrowth of the law and politics of the 17th and 18th centuries. I shall have to say more as to this conflict in my next lecture. Suffice it to say here that if, as I shall try to show on another occasion, the classical juristic theory is laid down by Coke and developed in the 18th century is untenable and must be abandoned by the jurist, the classical political theory is laid down by the 16th and 17th century publicists and developed in the 18th century in an age of absolute governments, must likewise be abandoned. Indeed, the French who have advocated it most zealously and given it the furthest logical development are now beginning to throw it over and are urging that sovereignty is not force from without but is public service from within. Properly understood, and shorn of the extravagances that it acquired through 17th and 18th century theories of natural law, the doctrine of supremacy of law is entirely in accord with such a conception. Public service, whether by a railroad company or by a municipal corporation or by the state, is not an end but a means. In neither case may it be left to the arbitrary will of those who perform it. In each case the social interest in general security requires that it be guided and regulated by reason, that it conform to principles and standards formulated dispassionately in advance of controversy upon weighing of all the interests to be affected. In insisting on the supremacy of law, the common law is not bound of necessity to stand always against the popular will in the interest of the abstract individual. Rather its true position is one of standing for ultimate and more important social interests as against the more immediately pressing but less weighty interests of the moment by which mere will unrestrained by reason is too likely to be swayed. I have made more than one comparison between the period of the Tudor and Stuart kings, in which the contests between courts and crown shaped our doctrine of the supremacy of the law, and the present period, in which contests between courts and majorities or pluralities have threatened to overthrow it. One more remains to be made which is by no means the least significant. At the very time that absolute ideas of lawmaking were dominant through the rise of the absolute theory of sovereignty and acceptance of the Byzantine doctrine that the will of the emperor has the force of law, a period of juridical idealism was at hand which proceeded upon a radically different idea. Our law and the law of continental Europe were liberalized and modernized in the 17th and 18th centuries, not by legislation, not by exercise of the will of any sovereign, but by a juristic doctrine that all legal institutions and all legal rules were to be measured by reason and that nothing could stand in law that could not maintain itself in reason. So today, while absolute theories of law as a mere expression of the popular will are current in political thinking, a return to juridical idealism is in progress. Once more jurists of continental Europe are writing elaborate treatises on natural law. In the United States, a revival of philosophical jurisprudence has definitely begun, and conscious attempt to make the law conform to ideals is once more becoming the creed of jurisprudence. This does not mean that jurists are going back to the 18th century conception of a set of fundamental legal principles of universal validity for all men, in all places, in all times, from which a complete set of rules might be drawn by purely logical processes. They are content to search for the ideals of the age and to set them up as a guide. They are content to seek what Kohler calls the dural postulates of the civilization of the time. But they are not content to abdicate all function and to concede that court and law have no more to do than to ascertain and interpret the will of the majority or plurality for the time being. The notion of juristic superfluity involved in such a doctrine is as impossible in the complex industrial society of today as the notion of legislative futility, held so generally during the hegemony of the historical school, or the notion of juristic futility added thereto by the positivists. Men are not born with intuitions of the principles by which justice may be attained through the public adjudication of controversies. The administration of justice is not an easy task to which every man is competent. It is no more possible for the people to administer justice directly or to control the course of justice directly than it is for them to administer medicine or control the course of medical science directly or to direct armies and control the course of military science. In each case, study of the experience of the past joined with scientific understanding of the problems involved is the road to the ends sought, and a technical body of knowledge inevitably results which may be mastered only through special study and training. Such was the element of truth in Coke's answer to his sovereign. Indeed, every attempt in legal history to go back to justice without law has enforced the lesson which the judges of England sought to impress upon King James at their Sunday conference. In this country we should have learned it when, in the period after the Revolution, the bitter hostility to lawyers and the attempt ruthlessly to break down the professional tradition, to ensure the access of the untrained and incompetent to the opportunities of the bar and to degrade the judicial office, resulted only in establishing the lawyer as the leader of the community and in entrenching the fundamental dogmas of the common law in our constitutions. We may be assured, therefore, that the supremacy of law, established by the common law against Tudor and Stuart, is not to disappear. We may be confident that we shall have, not merely laws, expressions of the popular will for the time being, but law, an expression of reason applied to the relations of man with man and of man with the state. We may be confident also that in the new period of legal development which is at hand, as in like periods in legal history, there will be a working over of the dural materials of the past and working into them of new ideas from without. We shall be warranted in prophesying that this working over will be effected by means of a philosophical theory of right and justice and conscious attempt to make the law conform to ideals. Such a period will be a period of scientific law, made, if not by judges, then by lawyers trained in the universities, not one of arbitrary law based on the fiat of any sovereign, however hydra-headed. For the notion of law as the will of the people belongs to the past era of a complete and stable system in which certainty and security were the sole ends. Throughout legal history law has been stagnant whenever the imperative idea has been uppermost. Law has lived and grown through juristic activity. It has been liberalized by ideas of natural right or justice or reasonableness or utility, leading to criteria by which rules and principles and standards might be tested, not by ideas of force and command and the sovereign will as the ultimate source of authority. Attempts to reduce the judicial office in the United States to the purely mechanical function of applying rules imposed from without and of serving as a mouthpiece for the popular will for the moment are not in the line of progress.